being in a team with people like you. So, beginning with the session now. So, today I'll be dealing with the topic, an introductory topic, trademarks law and advocacy, where I'll cover the basics of trademarks law, essentials required when you're filing a trademark, and what basically is a trademark. So, before we jump right into what is a trademark, let's deal with the bigger head, which is intellectual property. What is an intellectual property? So, as the name suggests, it's a property which derives from the human intellect. Anything made out of the human mind, the thought process, the creatives, the intellect or the smartness of the human mind is an intellectual property. We are in today's day surrounded by intellectual property. As Manya said, I'm an avid reader. So for me, the books are an intellectual property. So intellectual property is a form of an intangible property. So apart from the traditional concept of the property that we have, the physical property, for example, land or your mobile phones, or just the book that I am holding, not right now, but the books that I very fondly read, those are physical property. But what is an intellectual property? It's an intangible aspect of that property. The words that are written in the book are the intellectual property of that book, uh, wherein copyrights are applied. So when you hold a book in your hand, the physical book is an intellectual property. Is a traditional property, but whatever that's written inside, the copyrights in the book are uh, intellectual properties. For example, again, uh, you you wake up in the morning and you will brush your teeth. So the brand of toothpaste that you choose, Pepsodent or Colgate, so the property that you're holding, the toothpaste, is a normal traditional property, but then the brand in that property, the word, the Pepsodent or Colgate, all of that is an intellectual property known as trademarks. So I hope I've been able to clear the meaning of what is an intellectual property, and then what are intellectual property rights are the legal rights that are given to such creations in order to protect the creator, the inventor, and give them an incentive to keep creating more intellectual property, because more and more intellectual properties are there. It makes it easier for us to live our lives basically. So from the room heaters in the winter, which the invention which might be protected under patents, to your toothbrush in the morning, your favorite shampoo, your favorite book, these things are protected under intellectual property, so that it gives an incentive and promotes more and more production of more intellectual properties. So these are various different types of intellectual properties. Now, types of intellectual properties, there, more often than not, I would see people confusing the various concepts of intellectual property. For example, a friend of mine would say, "Oh, she has a very patented line," and I would, very instantly correct them that no, that wouldn't be a patent, that would be a trademarks. Whenever I say that I work in copyrights or trademarks, they would very often confuse the two words. So let me try to break it down for you. Trademark again is a name, a brand, a mark, uh, through which you basically relate with the origin of the product. For example, if I say the word Louis Vuitton, you instantly would connect with the fashion brand. If I say the word uh, Big Bazaar, then you would know which business I'm talking about. So these are trademarks, various marks through which you are able to connect with the origin, the producer, the manufacturer. Copyrights are rights that protect the creative works. If you look at a painting, so the copyrights, the physical painting is there, but then the drawing and everything, the copyrights protect the creativity of the artist in that painting. A writing, a book, so the written word, the expression is what is protected under copyrights whenever you see a creative work. Patents again protect the design, protect the inventions around us. Designs are the aesthetic features applied to any product, any article, These could be shapes, various patterns, colors, anything that is any such aesthetic aspect which is applied through an industrial process, whether mechanical, chemical, or manual. And geographical indications are an intellectual property that signify the origin, the geographical origin of that property. For example, if I so my personal favorite, being somebody who enjoys beverages, is Darjeeling tea. Whenever I say Darjeeling tea, I instantly relate it to the very famous Darjeeling tea that I very personally like. Or coming from a city like Allahabad, the Allahabadi guavas, I think they're called Allahabadi surkhas. So these are basically guavas that are red in color from the inside. So these geographical indications indicate the various geographical origins of a particular product. Uh, another one of my favorites would be Lucknowi chicken curry dresses. Now coming to the topic at hand, trademarks. Let's delve deeper into what basically are trademarks and what can be protected as trademarks and what cannot be protected as trademarks. So basically, the section ZB of the Indian Trademarks Act 1999, which is the statute that governs the law related to trademarks, defines trademark as any mark that is a graphical representation and enables a buyer to distinguish goods and services of one person from those of others. So, the very basic element of a trademark is that uh, it should be able to be represented graphically. Again, taking an example of your toothbrush. So whenever you see Pepsodent, you can see the word Pepsodent being represented graphically. So in order to be protected under trademarks law, a mark must be represented graphically. You must be able to see a graphical representation of trademark, and it must act as a signifier of the origin of those goods and services that would enable a consumer to distinguish the one goods and services of one producer from those of others. So whenever I say Domino's and Pizza Hut, so whenever I say Domino's, you will be able to distinguish the particular product, the particular pizza packaging carrying Domino's from those of other producers, that being Pizza Hut. So, graphical representation and distinguishing factor are two of the most important elements when it comes to trademark. And then section 2M, which defines marks, contains various different forms of uh, elements that could be protected as marks. So these are slogans, colors, products and their shapes, various letters and words and combinations of letters and words, logos of various pictures and combinations of these letters, words and logos, which are known as composite marks. Now, there are different types of trademarks as well. The first one being a word mark. So, word marks are basically simple words that are protected as trademarks. So, for example, if you look at this Coca-Cola logo, so the word Coca-Cola itself would be a word mark. However, a device mark is the representation, a particular fanciful representation of a word mark. For example, the cursive writing, the colored representation of this Coca-Cola would be a device mark. Similarly, the Just Do It symbol of Nike is a label mark because it's a particular way of representing the word Just Do It, along with the famous Nike symbol. Then there are service marks. So basically, service marks are different from a particular product mark. Product marks protect various goods, and service marks protects various services. Uh, I hope all of you are aware that there are 45 classes of goods and services, out of which classes 35 to 45 contain various services. So service marks protect various services. For example, the very famous Google, which provides us the service wherein we can put in our queries and search various things that we are looking for. Collective marks are basically registered by various groups or associations that signify any product coming from such group or association. For example, Tata, and their various wide range of services being Tata Steel, Tata Adventure, and everything. So anything that contains the trademark Tata comes under would be, a service mark of Tata. Certification marks are various marks through which there are certain measures or tests that products go through that signify that okay, this particular product is certified under certain standards, under certain measures that are important for those kind of goods. For example, the famous ISI symbol by the Bureau of Indian Standards, those are certification marks. Well known marks are such famous marks that have become famous or well known to such an extent that they require protection across various all the other classes. uh, Popular examples would be Bisleri or again Tata, uh, Mercedes Benz. So these are well known marks, and these are such marks that deserve protection across all the other classes. So if even though Bisleri is famous for their bottled waters, if I cannot just go ahead and use the word Bisleri from certain other products like hair shampoos or hair creams and everything, because Bisleri is such a popular and well known mark. Unconventional marks are such marks that are different from the traditional marks. So basically, as I said, all these above marks that I've just mentioned, these are traditional marks that you would see all around you in your everyday life. But then there are certain unconventional marks as well, which have not gained so much popularity as of yet, but with given the technical advances and advances in our law, such trademarks would in the coming time would become prominent around us. So famous color trademarks, certain unconventional marks would be color, shape, smell, or sound. So when it comes to smell marks, India does not have any particular developed, not in India but others as well, developed jurisprudence for that. But for others, for example, color marks, so the very famous purple color, when I say the color purple, uh, more often than not, whenever I say the color purple and ask people for what does this color signify to you, they would instantly say Cadbury. So these are certain, that is such an unconventional mark that has become associated with Cadbury. So you can see, right, the color purple has become a trademark and now signifies, for me it signifies the origin of Cadbury and their famous chocolates. Shape marks the shape of our Coca-Cola bottle, you know that is a shape mark. And then sound marks, there are very famous sound marks, the ting 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 of Britannia. And I recently came across Dunzo's. Whenever you open the app Dunzo, you hear a certain sound. So that is also protected under a sound mark. Moving on. So, registrability of trademark. There are certain rules and regulations when it comes to registering a certain trademark, and there are various grounds under which a trademark can be refused. And two broader headings are absolute grounds and relative grounds. So whenever you go ahead, towards registering a trademark, there are certain grounds of refusal. The first one being absolute grounds. So under Section 9, so Section 9 of the Trademarks Act deals with absolute grounds of refusal. The first one being a mark that is devoid of any distinctive character. Now, when it comes to a trademark, distinctiveness is one of the very basic and one of the most important elements when it comes to registering a trademark. So, distinctiveness, as I've been saying it time and again, is the ability of a trademark to be able to signify the origin, the ability of trademark of being able to distinguish itself from from other manufacturers in the market. Uh, then comes the second point, this that the mark consists exclusively of certain elements, certain words, certain indications that would indicate the kind of good, the quality of the good, the purpose of the good that is to be covered under such mark. So this is known as distinctiveness. This is known as descriptiveness. So basically the mark is descriptive of whatever goods or services that the mark is being covered for. Then comes the uh, the factor that the mark has become customary to the established principles or the practices on which the established trade in which the mark is to be applied for. Now, these three conditions are one of the most basic and important conditions, and so there's this concept known as the sliding scale theory. So when I say distinctiveness, the mark should be such that you know no other goods, no other trader in the market would be able to come up with such a mark. So referring back to the sliding scale theory, the theory says that the most distinctive marks are those marks that are coined or invented. So whenever you look at the word like Ibibo, go Ibibo. So whenever I say go Ibibo, it's an invented or coined word. You're not, whenever I say the word Ibibo, you're not able to form, a description of whatever goods it must be applied for. Uh, then comes then comes arbitrariness. So a mark is arbitrary when there's, even though there's a word. So basically a coin mark is such mark which does not have any meaning of itself, and it may so happen that through use it acquires a meaning of itself, which is the business for which it is applied for. So whenever I say go Ibibo, now it has acquired a meaning of itself, that it's used for the famous travel services. Whenever I say the word apple, now apple, even though it has a dictionary meaning, whenever I say the word apple for the products, the very famous Apple iPhones, or the computers that they make, so the word apple is an arbitrary word because the services or the goods for which the mark is applied for, the word itself does not signify the meaning of the word. Then comes suggestive marks. So uh, so for suggestive marks, the example, I'm not able to think of an example right now. So basically those are such words which may indicate towards the goods and services, but not exactly to such services. Then come descriptive and generic marks, marks which are such marks that are exactly descriptive of the goods and services. Example would be Naukri.com. So when I say Naukri.com, it gives an idea that okay, such a mark would be used for services such as providing job opportunities for people looking for jobs. However, there are certain descriptive marks, certain non-distinctive marks that become distinctive through use, and such distinctiveness is known as acquired distinctiveness. So basically, when I say distinctiveness, there are also two forms of distinctiveness. One is an inherently distinctive marks. Such marks would be, as I said, go Ibibo. And then there are certain marks that have acquired distinctiveness of their own, and those would be Naukri.com, which through use have become so famous that those marks have acquired distinctiveness of their own. Then there are certain other absolute grounds of refusal, such as those marks that would lead to confusion or deception in the minds of the public. There are such marks which would hurt religious sentiments of the people, or they contain scandalous and obscene matter. Obviously, those can't be protected. And then those which are prohibited under emblems and national symbols. Then, when it comes to shape marks, there are also certain restrictions. Such restrictions are that the mark results from the nature of the good itself. So, the example would be an egg tray. Whenever I say so an egg tray, you can't register the shape of an egg tray because that is an essential nature of the good itself. A mark that is necessary to obtain a technical result. So the square pin plug of certain plugs, those plugs and sockets, so those can't be protected under trademarks because those are necessary to obtain a certain technical result. And then goods that give substantial value to the marks that give substantial value to the goods, uh, again you can't protect those because that would then lead to monopolizing over such values that are again important for the use of those goods. Then there are relative grounds for refusal. So there are certain marks that are identical with an earlier trademark, and there is a similarity of the goods and services covered by such trademarks. Those can't be protected. And then those marks that are similar to an earlier trademark, and there is an identity with the identity or similarity of the goods and services covered by such trademarks. So, famous examples would be uh, the recent case of Starbucks and Sardar Baksh coffee. So again, Starbucks and Sardar Baksh coffee were providing similar or almost the same services. Those are, giving coffee, food, and beverages. And then the High Court said, directed Sardar Baksh to change its name from Sardar Baksh to Starbucks, because as you would notice, there is a similarity between an earlier marks, that is Starbucks, and then Sardar Baksh. Uh, Another famous example that you would all see everywhere is Adidas and Abidas and Abibas, how people just switch letters and then try to provide, similar goods and services. So, rights granted to a registered trademark. Once you register a certain trademark, you get certain rights through such registration. So, first is exclusive right to use the mark and exclude others from using the mark. Whenever you register a trademark, you get an exclusive right to use the mark, and you can exclude others from using any similar or the same mark. Uh, Once I have a registered trademark, nobody else can go ahead and produce any similar goods or services with a similar mark or the same mark. Right to sue for infringement. So once a trademark is registered, it gives the registered proprietor a right to sue for infringement. So in order to sue for infringement, Section 27 says that an unregistered trademark cannot go ahead and sue for infringement under Section 29. Uh, those those proprietors that have not registered their trademarks, the only remedy that they have is to go for passing off under common law rights. But with registration, you get the right to sue for infringement. A registered trademark is, again, when in various legal proceedings, it's a prima facie evidence of validity. A certificate of registration is a prima facie evidence of validity, and all that a registered proprietor needs to show is that their mark is registered, needs to show a certificate of registration. Moving on to importance of trademarks. Trademarks, again, are a very invaluable asset of any business. Take many very many famous businesses being Domino's, McDonald's, fashion brands like pantaloons, uh, other famous brands, the brands that you see everywhere all around you, you're covered by them. So registering a trademark gives brand recognition to the business. So whenever you look at a business, there are various elements of that business, and trademarks basically give a recognition to those brands. When it comes to Domino's, you see the word Domino's, you see that logo of Domino's, the red and blue logo uh, with dots. So that is a brand, and trademark allows the business owner to provide a recognition to that brand. It's a communication tool. So how do you know a business? You know a business through its trademark. You know a business through its identity, which is a communication tool. So a trademark is a communication tool for various businesses. uh, Again, how do you recognize your favorite brands? Everybody has their own favorite particular, classes of goods, particular not classes, but particular range of goods which you stick to, which you very religiously apply to. So I'm sure, like, things like shampoos, things like personal care products, again, shampoos, paste, toothbrushes, your favorite brand of noodles, Maggie is one of my first personal favorites. So these are communication tools with the audience. These are the marks, these are the elements through which a consumer relates with the producer. So how, whenever I go to a shop or whenever I go to buy anything, if I need a snack, I would go for kurkure, and I would say, yeah, I give me a kurkure. So kurkure itself is a brand. It's a brand, it's a trademark, and it's a tool for me to communicate and express the particular kind of product or the particular business that I want to go for. It makes your business easy to find. Again, as I'm speaking right now, I'm speaking various words for you. various words as examples. I've said Maggie, I've said Kurkure, I've said things like Pepsodent, Colgate, uh, Clinic Plus shampoo. So these are the ways through which a business makes itself seen in the eyes of the consumer. If I have to buy an item of clothing, I would go for something like H&M. I would go to Pantaloons. I would go to Benetton. So these are ways through which a brand makes itself, known and uh, known known with the consumers. So it's a way to make your brand known, recognized in the trade, amongst the various other competing trades in the market. It's a valuable asset. As a brand grows and develops, the trademark itself becomes a valuable asset. Again, as I said, these are properties in themselves. These are not traditional ideas of properties, but an intellectual property is an intangible form of property, and it becomes a valuable asset for a business over time. And there are certain businesses that have grown tremendously, and their trademarks now are valued at millions. For example, Google is a very expensive brand. It's valued to around uh, 700 millions or so. So these brands over time become a very valuable asset for businesses, and they can use these to leverage themselves in the market. Use these to create more income via licensing, via assignments. So these trademarks, if used effectively, if strategized effectively, can become a very valuable asset for any business. And in order to find, in order to make a business more valuable, that find out the value of a business, there are certain methods through which business valuations are carried out. So growth prospects. Now, uh, for a very famous brand like H&M, growth prospects in H&M are seen through how, in future, what are the possibilities of growth for this brand. And it's a very grow it's a very rapidly growing brand in India as of now, and one can see that, if strategized properly, if marketed properly, it can grow. Its prospects, its future in the market seems to be fruitful. Earning history again is one of the ways to evaluate a brand. How much has the brand earned? The trademark through which they brand their business has earned up till date. Location again plays an important role. So, for example, uh, you know bringing a business in a place where there is nobody else with a similar idea, or just there's a demand for the brand, again uh, again increases its value in the market. So, for example, bringing bringing a brand like, a clothing brand which makes winter wear in colder regions would, give that brand a better leverage in a place where it's not required. So location again is an important aspect, and a value of a brand depends from location to location. So at one location the valuation would be higher, and then at other location it would not be as high. Concentration of things like the clientele, the potential clientele, raw material, stuff like that also is an important aspect. And then again, it depends from place to place. So valuation would vary from place to place. Staff and management. So, better skilled the staff is, the better are the prospects. So there is, an element which distinguishes certain brands from other brands. So if you go to any local hotel in your city, you wouldn't be as satisfied as, some better five-star resort or a hotel, because again, the way the staff interacts, the skills of the staff interacts with the customers is another important aspect. And then reputation of the brand again is an invaluable asset. The more popular the brand is, the better would be its valuation. So if you compare a very famous brand with some local brand, obviously that famous brand, that well-known brand which has a reputation of its own, would play a better role in its valuation. Now we come to evolution of trademarks law in India. So before 1940s, we did not have any such official trademark law in India, and traders would have to rely on infringement and passing of laws applicable under Section 54 of the Specific Relief Act. And registration, there was no certain fixed way of registration of trademark, and Indian Registrations Act was obtaining a declaration of ownership under Indian Registrations Act was a way for the traders to protect their trademarks. And then in 1940s, based on the English Trademark Act of 1857, uh, the Indian Trademarks Act was passed. However, after the independence, the Trademarks and Merchandise Act was passed, which replaced the earlier registration in order to, meet with the growth in commerce. Then again, in 1994, the Trademarks Bill was introduced. However, the same was lapsed. Is, is anybody trying to speak something?
I guess no. It was by mistake.
Then again, in order to bring the Indian legislation according to the TRIPS agreement, the Trademarks Act 1999 was passed, which replaced the earlier Trade and Merchandise Mark Act of 1958, in order to bring the Indian trademark law in line with the current developments, in order to bring the Indian law at par with the globalized law, in order to make it easier for foreign entities to come into India and Indian entities to move abroad, in order to unify the Indian law with the globalized law. And again, in 2017, the amendments were made into the act, which made it further more simpler. So as of today, we are governed. The Indian trademarks law is governed under the Trademarks Act 1999, and which is the guiding principle for today's law. Which brings me to the end of today's session, and I'm open to questions now. Anybody who has any questions can please go ahead.
Okay, I guess session was quite interesting and like everything was covered. So we have a few questions here. So one of the question is, what is the difference between a certification mark and a license?
Okay, so a certification mark, again, as I said, is a way to signify to the traders, to the consumers, that certain products are covered under, uh, are compliant with certain measures, or certain yardsticks that make it, I would say, safer, or make it of a certain quality, that yeah, you can trust that particular mark. And what was the other mark, other kind?
Certification mark and license.
License is different from, license is not a form of trademark, but a way to, uh, a method through which any business can license others to use their marks. So license is basically a trademark proprietor giving permission to other sellers in the market to use their brand. So certification is more with respect to the quality of the product, and license is a form of permission through which a registered owner can permit others to use their mark.
Yeah, they are totally different concepts. So we have one hand raised from Sabya Sachi Chakrabarti. Are you there?
Yes, ma'am. I have one question regarding that section 9 part, or even section 11 actually. So there is some time limit to file a reply if the section 9 or section 11 objected comes from the trademark authority. My question is that if the time limit has expired, say maybe 2 months, 3 months, whatever it is, and somewhere I have to file a reply. So what can be the strategy? Should I wait? Should not I file a reply because it's already time barred? Or I file a reply, or rather go for a condonation of delay or something else. And if I don't file a reply, then what would be the consequence? And again, I have to again go for trademark application.
So if you don't file a reply, then you will have to file a trademark application, because that application will be deemed to be abandoned on your part. And even if the time lapse, so once the examination report is issued, there is a 1 month of time period that you are given within which you are supposed to file a reply, but the time period is counted from the day it is served upon you. So once it's served upon you, you have 1 month. You should file a reply within that. Ideally, you should file a reply within that time period. However, if the time period has lapsed, not a long time has passed, you may again give a reply, but then you will have to explain your delay, and with a reasonable reason, give a reasonable reason as to why you were not able to file a reply within that time period.
Thanks, ma'am.
Yeah, and the filing aspect will be covered in tomorrow's session. So the filing aspect questions can be answered tomorrow as well. Uh,
Um,
so I can see a hand raised by Laksh. Yes, Laksh, you
I
can go
want to
ahead.
ask, can literary and dramatic work comes under trademark or it could be only in copyright?
Yeah, it's protected under Copyrights Act, copyright
It
law.
it could not become under trademark.
No, it's not covered
Okay.
under trademarks law.
Thank you, ma'am.
So, so we have one question from Lavanya. What is the validity of trademark in India?
So a trademark is valid for 10 years and then renewable for further 10-year time periods.
So one question from Shravani. What is relation between trademarks and consumer rights?
Okay, so consumer rights are covered under different department of law, that is Consumer Protection Act. Uh, However, there is a jurisprudential connect between trademarks law and consumer and public uh, interest. A registered trademark or even a trademark is registered registered in a way that the public relates with that particular trademark for certain categories of products. And if somebody else tries to infringe that trademark using any similar trademark or the same trademark, that would be also contrary to the public interest, because that is not only cheating the registered proprietor but also in a way deceiving the public by providing substandard products with a similar trademark. However, consumer again, I would emphasize that consumer rights are protected under different law altogether, and trademark law is covered under Trademarks Act.
Yeah, one of the example which you shared of Adidas and Abibas. So it is
Yeah.
kind of misleading the consumer. So there's one question from Lavanya, but okay, we should go for patent first or the trademark?
So yeah, patents and trademarks are again different. I would say it's not really about what you should go for first, but it's about what you should go for. So if you have an invention, then you should definitely go for patents to protect the invention, but then at the same time you should also go for trademarks to protect your brand name or whatever mark that you are using to market that particular invention in the market, because those two forms of intellectual property are again protected under different genres of IPR protection laws.
So we have hand raised from Laksh again. Laksh, do you have any question?
Ma'am, I want to say that patents are only for medicines only, or it could be used for other things also. Patents are only used for medicines purpose, no? That's I'm asking, or is used for some other diversification also.
Yeah, so patents again in itself is a diverse area of intellectual property rights, and uh, medicine is a part of property or invention that is protected under patents. So there are mechanical patents also. There are chemical patents also. There are biochemical patents also, if I'm using the correct word. So medicines is a part of different forms of patentable inventions or processes, I would say.
So we have another question. Is there any exam like patent agent exam to practice in trademarks, copyrights, designs, etc., other IPRs?
Yeah, so I do know that there's trademarks agent exam as well. Lawyers don't need to crack the trademarks agent exam, but I think there are other qualifications or eligibility criteria that's required for trademark agent exam.
I guess we don't have further questions. I'll be sending the feedback link. Uh, so I was thinking to have an exercise, Sonal. What do you suggest? We'll ask the participants to at least type in two trademarks which they see around them. That could
Sure,
be fun
you
exercise.
can they can give one trademark and any sort of funny infringements that they have come across, for example Adidas and Abibas, or anything that they might they
Yeah.
would like to share with us.
So like the trademark which I'm using right now is Samsung phone I'm using, so Samsung trademark. So similarly, we can, if participants are interested, they can write in the chat box. Like one of them by Varun Bisleri and
Yes,
Bilseri. Yeah,
definitely. I've come
that
across a
one is
lot of
interesting.
this.
Yeah, there's a lot of infringement cases also.
Yeah,
Re-
really.
Reebok and Reebok, a good one. HP and Oppo, quite a safe answer. These two are around me by, okay, unknown user. Okay, so we have one question from Basudev. There is authorized car dealer company who sells cars in brand cars in India, but the brand company doesn't provide warranty. But the authorized car dealer company provides warranty. Okay, so does it come under trademark infringement?
Wait, there's a
Uh,
car dealer who sells car brands in India but does not. So again, warranty I would say is covered under different aspect of law and trademarks. I think the question requires a little bit more detail in order to.
yeah. Puma and Puma, another answer. Huda and Huda, quite an interesting infringement cases. So by the time I request everyone to fill in the feedback form to mark their attendance, and we will proceed with the ending of this session. So I hope by now you all are clear with the basis of trademark, what is trademark, types of trademark, what mark can be registered as a trademark, the absolute grounds of refusal, the relative grounds, and business evaluation also. So it was very well covered by Ms. Sonal. And if you have further questions, you can ask in tomorrow's session. We have two sessions scheduled tomorrow, so please do check the schedule. And I would like to thank Sonal for this wonderful, informative session, and for all the participants for patiently listening the session throughout. Thank you everyone for joining in. Thank you, Sonal.
Ma'am,
Thank you.
ma'am, excuse me.
Uh, yes, yes. Who's this?
Um, Good
Yeah.
afternoon, ma'am. Ma'am, I just text one question in chat box. I want to answer related that. That sometimes there is a contradiction between trademark and patents. So how this problem has been sorted out by regulations?
Confusion
Some
between
products,
trademarks and patents.
no, it's not confusion, ma'am. Sometimes some products are there like color combinations and all. Sometimes inventions and brand sometimes gets contradict to each other. So what type of means solution is found to where it to be registered properly?
Okay, so again, when it comes to trademark, you looking at any particular product, again, take a medicine. So the process of the medicine or an invention would be, uh, a hair dryer. Somebody, invents a particular kind of a hair dryer, which, adds an inventive step to that hair dryer and makes it different for other hair dryer brands in India. So that process through, the process of making that hair dryer or the inventive step in that. So the invention aspect, the process of making that hair dryer would be protected under patents. And if that particular inventor now decides to sell that brand in the market, and for example, take LG, so that inventor is LG, so and then they so LG has its own registration over the mark LG, but then again they come up with